Good afternoon, everyone. It's usually not the best position to be in to go last after a two-day conference, especially when you're not speaking on a topic that is exciting. I don't think anybody see amendment to legislation as very exciting. But it is critical and essential, so here we go. So, prospective amendments to the Proceeds of Crime Act. Prospective, very important to note. We're in initial stages with these amendments, and we still need to do consultation, etc. So, by way of a little background, as previously mentioned, we, as a country, did our NRA in 2021, and we have been assessed as medium high. So this means we really have to be robust in our efforts against AML. The main threats identified included lottery scamming, trafficking in narcotics, arms, corruption, bribery, cybercrimes, fraud, importation of counterfeit products. The medium-high rating has also impacted Jamaica. It was also impacted by Jamaica's porous borders, geographic location, and pace of investigations and prosecutions. I'm highlighting that because I'm hoping that some of these amendments will aid in this area. High level of informality and significant use of cash in the economy as well. So, Jamaica's anti-money laundering, counter-financing terrorism, and counter-financing of proliferation regimes are governed by legislation, and I just listed some, right? The POCA, the Terrorism Act, the United Nations Security Council Resolutions Implementation Act, the Corruption Prevention Act, and the Integrity Commission Act. Legislation over the years have gone through amendments, some of these that were mentioned and others, to ensure that the framework is commensurate with this international standard and the requirements, what is necessary. And certainly they are ongoing. To complement the legislative framework, there exists extensive network of law enforcement and supervisory or regulatory agencies that are adequately empowered by statute and are increasingly collaborating in the area of AML and terrorism financing. Notwithstanding the legislative and operational efforts Jamaica has made, there are still considerable gaps to be filled to strengthen Jamaica's AML-CFT regime. In this regard, Jamaica is currently seeking to amend the legislation, and I'm naming two main areas: Unexplained Wealth Order and Asset Recovery Incentivization Scheme. With respect to the Unexplained Wealth Order, UWO for short, it is to be noted that the Most Honorable Prime Minister, in a statement to Parliament in 2018, articulated that the overall government response to criminal ecosystem has to be more sophisticated than solely direct action on criminal gangs. It must be extended beyond the JCF and the JDF to other enforcement arms in the government whose efforts address unexplained wealth, public order in the towns, illegal construction, etc. Therefore, at the various highest levels, there is support for the introduction of UWOs. With respect to the unexplained wealth order, some issues to consider. It is important to prevent proceeds of crime from being used to fund lavish lifestyle or reinvested in support of criminal activities. I'm sure we can all agree with that, right? When they fund their lavish lifestyle, they become an example for others. And young persons within the society, especially those that are wayward, might aspire to these things. And I think reinvestment to support criminal activities speaks for itself. We definitely don't want that. While the Corruption Prevention Act and the Integrity Commission Act prescribe measures for public officials and parliamentarians to make annual statutory declarations, there is currently no regime to treat with individuals in the wider society to give account for the legitimacy of their wealth. Therefore, it is our belief at the ministry, and certainly the Honorable Prime Minister, as was demonstrated, that we need to strengthen the AML regime to include UWO, which will bring scrutiny to unexplained wealth in the wider society. So what is unexplained wealth order? By definition, unexplained wealth itself is the ownership of assets by an individual that is disproportionate to his lawful earnings. UWO will allow the court to compel an individual to explain the sources of their wealth, which is the shifting of the onus of proof to the individual to prove their asset or wealth was acquired through legitimate means. If the individual is unable to substantiate the lawful source, then enforcement authorities will be empowered to take the necessary steps through the court to restrain those assets. So in looking at this issue, we were guided by what has been taking place in some other jurisdictions. We look at the UK, and there was a landmark case, and it's listed there. In the interest of time, I won't go through it. We also looked at Northern Territory of Australia, which implemented their legislation in 2000, and it allows the judge to grant UWO when the person's total wealth exceeds their lawfully acquired wealth, which does not have to be linked to a criminal offense. And closer to home, we looked at Trinidad and Tobago, which has a similar constitutional framework to that of Jamaica, and has successfully enacted the UWO. So we're hopeful that we will be able to do so. It allows the High Court to grant a preliminary UWO based on reasonable grounds to suspect that the total wealth of the respondent exceeds the value of his lawfully obtained wealth. This requires the individual to file a declaration and appear before the High Court to answer questions relative to his assets. The High Court then decides on the necessity for and then subsequent approval for a UWO. Now, we're looking at other jurisdictions, but we will be designing our own that we think is best for our jurisdiction. So, but this is part of the research that we have done. So, where are we with the amendment to include UWO? The ministry is currently developing a policy paper. So we are at an early stage. Stakeholder consultation is to be undertaken in some instances and continuing in other instances. Of course, because of the nature of this amendment, consultation with the Attorney General's chambers will be important to ensure all constitutional impediments are addressed. But we are still aiming to do this in the 2023-2024 financial year. Okay, the other major area being pursued is the implementation of an asset recovery incentivization scheme, or ARIS. Jamaica is in the process of developing an ARIS and regulations pursuant to Section 43(3) of the Proceeds of Crime Act. This type of scheme operates in most jurisdictions with proceeds of crime legislation. While the beneficiaries and distribution formula differs from jurisdiction to jurisdiction, the funds collected are usually reinvested to improve the capacity of law enforcement or the criminal justice system as a whole. Since Jamaica's enactment of the Proceeds of Crime Act in 2007, there have been calls from various quarters for the activation of an asset recovery incentivization scheme. The intent is to provide additional resources to agencies who contribute to combating AML or in fighting financial crimes, and the recovery of assets to improve their capacity and operational effectiveness. This would be done by allocating the resources and the assets recovered from the criminals directly to law enforcement entities. And of course, it will and should be like an incentive and further enable entities to successfully pursue more criminals and assets to remove the profit from crime. So, in relation to the ARIS, this is the section that we're focusing on in relation to the amendment. I'm not going to read through it, but just to at the bottom where it speaks to the benefit of Jamaica's criminal justice system. So, sums would be paid to the benefit of Jamaica's criminal justice system. However, this is general and not specific. So currently the legislation don't specify which entities and how much or what percentage would be allocated. And with respect to the sharing of the Forfeited Property Act, Section 5, and you can see it there at the bottom again where it says used in accordance with directions in writing issued by the Minister for the purposes of health, education, and national security. Again, it doesn't specify the entities or go into how much, what percentage specifically is to go to these entities. Based on FID data, this might be dated from 2018, 2019, 2020, 2021, approximately $235 million were remitted to the consolidated fund. And this figure includes monies received through seizure and forfeiture of cash and other assets, and funds received through post-conviction orders of approximately 15 million. So you see the amount of money. And with Darian's presentation yesterday, he went into more detail. He showed fancy cars that were seized. How many times we've heard that the police or other agencies don't have vehicles? What if these funds could be diverted directly to law enforcement entities to bolster the fight against AML and financial crimes? Maybe there could be increased investigations, charges, and prosecution and confiscation. I think we should flip the script on them. And I personally think it would be great to use the same resources taken from criminals to go after them. What do you think? I'm sure MOCA, FID, JCF, and everybody here would agree with me. So the proposed amendments are for monies received through pecuniary penalty orders under Section 44 of the Proceeds of Crime Act to be distributed as follows. And they see there 35% to the Ministry of National Security, 35% to the Ministry of Justice, 30% to the FID. And please remember, these are proposals and may change after more consultation with stakeholders. So those are not fixed right now in terms of the percentages and the allocation. And with respect to proposed amendments for monies received pursuant to Section 5.1 of the Sharing of Forfeited Property Act to be allocated to a separate fund in accordance with Section 5.3 to be distributed with the written directions of the Minister as follows. So a percentage to the Ministry of Health, to the Ministry of Education, to the Ministry of National Security, and 30% to the FID. Again, the details and specific amounts, if they are to be named in this amendment, will be determined after further consultation. So where are we with respect to the ARIS? So stakeholder consultation continues. Proposals are still subject to change, pending further consultation, as I said before. Cabinet submission is being prepared for approval and will be subject to consultation with our stakeholders as well as the AGC, Attorney General's Chambers, for review. And we're hoping that this amendment can also be done in the 2023-2024 financial year. So that is my presentation. Thank you for your attention.